my father's a veteran. I guess that made me sort of hardcore too, that you have to speak truth to power. You have to do it. If not, you deal with the results of being silent. And I think that Clark County's had enough of that from Department 19. And I think that we have work to do.
Alex here with a perspectives video on removing Judge Kephart from the bench. Chief Deputy Public Defender and candidate for Department 19 of the 8th Judicial District Court, Fikisha Miller calls the voters to action in urging the ouster of District Judge Bill Kephart. Let's go straight into it. We are here with Fikisha Miller. Why don't you start off with a bit about yourself and your campaign for Department 19 of the 8th Judicial District Court?
Hello, Alex. Thank you. My name is Fikisha Miller, and I am a district court judge candidate for Department 19. I currently am a chief deputy public defender here in Clark County, but that's not all that I've ever done. I've been practicing law for the last 18 years. And in that 18 years, I have been a criminal defense attorney, a prosecutor, a judicial commissioner. I actually taught at a community college, training paralegals, and I've also run my own firm. So I have a broad breadth of legal experience. Department 19, of course, is both a civil and criminal split docket, and I do have that experience on both sides. In my small firm, I did do a substantial amount of civil experience, including general matters that most people would come in contact with lawyers with. So that includes personal injury, workman's comp, some employment discrimination. I was also general counsel for a general contractor, litigated real estate matters. And so I have a broad breadth of experience legally. And I am mounting my campaign in order to defeat an incumbent. And I guess we can talk about that later in the interview. But I would appreciate your support, and I'm happy to answer any questions.
Okay, yes, we are going to get to some of those. In fact, the next question goes straight into judicial neutrality on the bench. One of the things we do, by the way, is keep track of appellate dispositions, and we have seen appellants raise this issue before, though we haven't seen any cases reverse on it. We wonder sometimes, where does the Supreme Court draw the line as to how far a judge can go when, I guess you could say, helping out one side or the other?
I don't think that the Supreme Court likes to have bright line rules, uh, even though, of course, we're all supposed to maintain the appearance of impropriety. That's in our judicial ethics. And I think that when you review a record, it's very discretionary on whether or not you believe that a judge has been neutral and fair to both parties. It's one of the things that in the Supreme Court's review, they look at the factual analysis, they look at the record, the hard record, which is why it's really important to have a knowledgeable judge that's been a knowledgeable lawyer, specifically someone who's done a lot of trial work, so that you're making what's called a very definite and very finite record. A lot of times, some of the cases that I've reviewed from the Supreme Court, they will routinely note, mention, and fail to find cause in issues where the record is not adequately preserved. So their discretion, I think, is broad. It's supposed to be broad. Just by the nature of litigation, by having an adversarial process, someone wins, someone loses, and the Supreme Court has to have a broader view with regards to whether or not there really was an actual impartiality that's been demonstrated. And so I think that it is broad enough for them to try to catch the most abusive cases. But when you're reviewing someone else's work, all the judges are elected, all the judges were licensed attorneys before that. All of the judiciary, I think, has a certain amount of deference to the judges or to witnesses, even in that matter, when they're reviewing trial transcripts, in saying that the people in the room are the ones who have the best understanding of how that record was created and any perceptions that were created in it.
And I believe that I have reviewed some articles on you having confronted Judge Kephart on his ability to remain neutral on the bench. Do you want to go ahead and elaborate a little bit on that or touch on that issue?
Oh, absolutely. The reason why I chose to run in Department 19 and chose to run against Mr. Kephart himself is because I do not believe that he has demonstrated on a regular basis his neutrality. I actually made one of my campaign points his treatment of people who appear before him now as a judge, but also his record back when he was a prosecutor. So his uh, for people who don't know, the most one of the most recent scandals. I hate to limit it because I'm always finding out more information. One of, I mean, literally, I don't know if you know this, but Rimberger just came out from the federal courts reversing a case where he was a prosecutor, citing that the co-defendant that testified in that case actually she came back later and said she was told not to testify about the deal that she was making before she testified against her co-defendant. So literally, even in the process of my campaign, more and more courts are reviewing his actions as prosecutor and finding misconduct, finding reasons to reverse convictions, which of course for the taxpayers of Nevada, that means more trials, more work. For the victims of those crimes, that means the people that they thought were being punished for them were in fact not correctly being punished for them, even if they committed the crime at all. So I mean, the whole lack of balance just throws the whole system out back. So Mr. Kephart was also cited in 2017 for violating the Rule 1 of judges, which is that not only do we have to remain impartial, but we also have to avoid the implication of impropriety. That's a magic term, which means that you shouldn't look at our actions as judges as being something that would be inappropriate. And in that case, that is another case where a criminal defendant spent over 15 years in prison. Ms. Lovato spent over 15 years for a crime that they could not prove. Those charges were ultimately dismissed, but he came out and publicly commented on the case. So that had occurred once again when he was a prosecutor. So the idea of maintaining neutrality and not forming an opinion, and definitely, not trying to present that opinion to others in a public forum where it would also taint a potential jury's reading or understanding of the facts from the evidence that's actually presented in front of them. I mean, not only is it inappropriate, it is actually Rule 1 of the judicial rules of ethics, of our canons. And so lawyers have the same, we're supposed to do the same thing as lawyers. Of course, the responsibility is much higher as a judge because as a judicial officer, you reflect the system. And so everything that you do reflects only your perceptions of the justice system, but also most importantly, what citizens believe about the justice system. So the idea that judicial neutrality is a air quote, and we want impartial judges. I'm sure you've heard, and your viewers have heard at least 100 times. Oh, I'm going to be fair. I'm going to be impartial. I'm going to be fair. I'm going to be impartial. That really actually means something to our system of justice, because if your judge has already commented, or a judge has already commented on whether or not somebody's guilty or innocent, I mean, it's very difficult to overcome that statement. You can't take those words back out of the air. And to have someone who's been practicing so long, Bill Kephart has been practicing, I think in our actual debate, he said, I was practicing while you were in law school. And I was like, but you're still making the same mistakes. The same mistakes is like, we're supposed to be better than that. Prosecutors are given a lot of power, and you want prosecutors that are responsible and moral, and they have a driven force. It's not just the force to win, it's supposed to be the force for good. At least that's how I was trained when I was a prosecutor. And so if the case is no good, if you violated people's rights, if you even though you might be able to prove the case, you've got to look at what that means for everybody. The same thing works for judges. You've got to try to maintain that neutrality. And I mean, lawyers aren't supposed to comment publicly on an active case unless, given some restrictions. But I mean, the idea is that most definitely a judge should not comment on a case that's coming back on appeal. There's going to have to still have jurors pulled on it. It's still a live case. And so I think that, and I actually reviewed that interview, I think that he was he's so defensive about his own work as a prosecutor. He was just trying to defend himself, and at the cost of not only our ethics, but also at someone else's liberty. And that sort of sums up Judge Kephart.
You gave me so many points to go off of, but I want to lead with the one you ended on, which was his response to being confronted by the exoneration of that particular defendant. My understanding is that both Judge Herndon and Judge Kephart were in some way connected to the prosecution of that individual, but both of them responded differently when they were confronted on it. Do you want to go a little bit into the contrast between how Judge Herndon dealt with the exoneration of that individual and Judge Kephart?
I will, to a limited degree. For a full caveat, I always believe in disclosing everything. As a Chief Deputy Public Defender, I'm currently assigned to Judge Herndon's docket. He's the judge that I appear before 2 times a week, every week. And so with that caveat and that disclaimer that I actually actively work in front of him and have for years, I will take Fred Steese's position. As you know, they were both involved in the prosecution of Fred Steese. And so when I talked to Fred about it, because Fred is a supporter of mine, and we've talked, especially because I'm running against Kephart, he is a big supporter of mine. And we talked at length about his experience in prison, how he experienced the justice system, and, and everything that we're trying to do to help him. And so, sorry, I get a little shook.
Oh, no, it's real. It's just, real, authentic. It's an honest.
Yeah, but it's tragic, And so Fred's position is that what they did was wrong, but at least Herndon apologized, took personal responsibility, actually went to the legislature to try to get some reparations, for lack of a better term, for Fred. And so there is a certain amount of understanding there, at least. I mean, when you make a decision, the very least thing you could do is apologize. And then secondly, try to make what amends you can, even though 22 years, So Kephart, on the other hand, I have repeatedly heard, I have not heard this personally from him. We do not have that type of relationship where we speak. But I've heard from many people who talk to him and other lawyers that he still believes that Fred Steese is guilty, and that, he did the right thing, and that he has constantly refused to learn from his errors. And it's just sort of, that's not just, that's in his demeanor, that's in his public response, that's in everything, personal responsibility. I've made a central tenet of my campaign that I'm running to hold Kephart responsible, that I hold the voters responsible for educating themselves, making good choices, because these are really life and death decisions by who we elect to sit on the bench. And so with that regard for personal responsibility, I have yet to see Mr. Kephart take personal responsibility for any of the misconduct that, not that I've alleged, but has actually been proven and held in our Supreme Court, in the federal courts, in the Ninth Circuit. Every single level of court has reviewed his behavior, and they have reversed the court. They have reversed the cases overwhelmingly. There's so many of his cases, and he touts about his criminal trial record when he was a prosecutor, but so many of those people were innocent that we're fighting to set free literally decades later. And even during the course, our campaigns technically started in January. So in this last 5 months, we're taping in May, there's been another case that's come out that's been reversed by the federal courts. And so that is yet another case. So the further you dig, the more problems there are, and zero responsibility, or just really no personal responsibility. And I really do believe in the interviews and during the debate and everything that I heard from him, and that to his core, he believes he's right. And so you can't just fix that. I mean, literally, he's been doing this since the 90s, and he's been reversed all of these times. He doesn't believe he's done anything wrong. He believes that he should be reelected, and he believes that he's doing the right thing. That's what he believes. I truly believe that he believes he's doing the right thing.
Yeah, it's interesting. There's so much that you mentioned that we can touch on. I mean, at the end of and
We could talk an hour.
well, this is actually great. I think that these interviews where we have this sort of back and forth, those are typically the better interviews that are more engaging. You touched on legal error, which I wanted to hold off, but it really does matter, because at the end of the road, that's sort of the consequence of it all, how it impacts the ordinary person, because it affects their view of the justice system or the legal system when they see us doing all these do-overs, and how it impacts judicial resources and stuff like that. And I do recall Justice Hardesty confronting Judge Doug Smith on this, actually, in a footnote that was like 2/3 the length of a page, where he went into all these mistakes that the judge made. And it's interesting also that you mentioned cases overturned, not necessarily where Judge Kephart was presiding, but where he was a prosecutor. It's unfortunate that we don't track those details on our website, but it is interesting. And we have seen this perspective by some attorneys that if they further positions that are going to lead to something being overturned, it's not really their fault. The judge shouldn't have believed them or shouldn't have went with it. We have seen that attitude before, and it frustrates the judges sometimes, because they kind of feel like, well, I trusted this guy and he was wrong, and now I got overturned. And it's definitely this almost combative adversarial dynamic, not just between the two attorneys that are in a case, but even the bench. We go next into judicial demeanor and temperament. I was going to ask you sort of a general, almost generic question on judicial demeanor, but I want to to start this one off with the perspective of some of Judge Kephart's supporters, to let you sort of confront that perspective. And that was that Judge Kephart was upset or angry with a juror trying to get out of jury duty, and that's a very common thing, and it grinds some judges' gears. And I think let's have you sort of confront that defense in dealing with this issue, rather than just dealing with judicial demeanor and temperament generally. Go ahead.
Okay, so with regards to getting upset at a juror, the reason why I'm laughing is not because I'm not trying to dismiss the question at all, but the idea that you as the judge are going to get emotional and upset at someone sort of answers the question in itself, right? The very nature of the judicial role is to deal with the public, right? I mean, there's no way that you can avoid it. You're only going to deal with members of the public, lawyers, clients, defendants. They're all members of the public. And so you have to know that there are people who are going to try to be too honest, right? Be upfront and be like reveal too much that we're not even asking. There's going to be some people who are upset that they have to be there, whether you're in a jury, a lawyer, or a client. It's just part of the job. You can't get angry at people when that's a normal response for the situation. People don't like jury service. They should, because it's fascinating, especially if you get on a rather quick trial and you can sort of see the whole thing. I personally served as a juror before, and so I had that perspective, but also in all the jury trials that I've had, I try to go back and talk to the jurors because I want to know what their experience was like, how they took the case, how they took my presentation, because that feedback is so critical to me being a better lawyer, right? Or to, if there's something that they saw that I missed, maybe it was an ordinary perception. And I'm a dork. Lawyers are nerds. I got that. But I'm sort of super dorky and super hyper on it. I have a communications degree. So I'm always concerned about my presentation to a jury. And I also want to know what they thought about the process, if they thought it was fair. What can we do to build more respect? Because honestly, lawyers have a bad rep sometimes. Criminal defendants have a bad rep sometimes. The police have a bad rep sometimes. Everybody, and you want to try to get to the truth of it, at least I do, as much as possible. So the idea that the grown-up in the room is getting upset at someone who's not behaving well, I mean, that's sort of telling you what's wrong with the grown-up, right? If you're the grown-up in the room, I mean, lawyers are passionate, clients are passionate, jurors are passionate. The job of the judge is to manage all of that, somehow arrive at justice and make sure that we stay on task, right? It's not, and I take this my relationships with my clients. It's not personal. I'm going to give you really, really bad news a lot of the time. That's my job. My job is to represent you. That means you have to know everything. Guess what? You might not like it. You might not be happy with me. That's not my problem. I mean, that's not. I mean, I can't have that attitude that it's between me and you. I mean, my job is to make sure that you have the best defense, that you have the best outcome, and then sometimes, especially working for indigent clients, if you let the personality get in the way, you can't get the work done. And so that is triply so in passionate matters, if you're talking about freedom or livelihood or money or any of those things that affect people. Of course they're going to be emotional about it. You have to understand where they are and try to get them to the place that you need them to be to do your job. But the idea that anger is the response shows you a lot about someone's temperament. And I think that that's just not the right emotion from the bench.
Right. I think that was an excellent answer. I think you handled it well. So we're just going to go into one more question here. I'm going to tie harmless error and prosecutorial misconduct together. When we post appellate dispositions, I'm going to say we always get a comment. What upsets most of the commenters, in fact, one of the attorneys who's kind of a diehard fan constantly brings this up, is how often the Supreme Court finds prosecutorial misconduct to have been deemed harmless, and I guess the prosecutor isn't really confronted any further beyond that. You can really take this question any way that you want. You can deal with either of those 2 points, but one of the things that I hope you cover is what harmless error is, because the public doesn't really understand the concept behind that. So go ahead.
Okay, so the concept of harmless error is the concept in the broad sense, and I'm going to put on my teaching hat. In the broad sense that in any trial with all of these moving parts, all of these questions, all of these witnesses, all of this testimony, all of this physical evidence, that people can get some decisions wrong, right? Like maybe if you're talking about a document, well, all of the documents got to go in, but maybe if you're talking about something that's just a little clerical issue, something's not headed the right way, or if I'm just trying to think of, without having a good case, like to sort of work off what harmless error would be. But what it means is that even though there was a wrong decision of the law or quite possibly a wrong finding of fact, just because you got one thing wrong doesn't mean that you get an entirely new trial. That's not a clean slate. That yes, there was an error, but whether or not the error was valuable or not. So think about it in baseball terms, right? You have unforced errors, but the question is whether or not the other team was able to turn around and score off of that, right? So the concept of harmless error is that while there might be a flaw or while there might have been something that was done wrong, especially in the tone of the prosecutor, like maybe they argued something wrong or tried to shift the burden of proof to the defense. They might have said something in closing argument that's wrong. It's a wrong statement of the law, right? Or it was the wrong tone, or if it was really aggressive. Like those are all errors. You shouldn't be doing that. Slap on your wrist. But it doesn't add up enough to prejudice the trial in such a way so that the whole trial has to be done all over again. So that is the concept of harmless error. And it makes sense, right? You shouldn't have like a small little technicality that maybe didn't even change anybody's mind, or maybe the jury didn't note it, or maybe it wasn't anything consequential in the scope of the whole trial. You shouldn't force people to try cases over and over again if the error is harmless. The trick about that is that whether or not it is harmless is a matter of discretion. And you can have enough errors add up to make it prejudicial, and therefore the whole trial should go back. But as in everything else in the law, this is a gray area, right? What the Supreme Court considers harmless and what the litigants actually consider harmless, totally two different things, right? I've been in the middle of trials or motions and thought like, that's not the right, I don't believe that is the correct interpretation of the law. And when I go back, I try to be right. I was right. But then in doing my research after that, I find 3 cases where other judges made that same distinction and they found that it's all harmless error in the wash. So it's like, is that something you want to try to fight when they've already said that it's harmless, even though you felt like it really tangibly changed things for you? And so let me give you an example of that with regards to prosecutorial misconduct, and something really simple for people to understand. Like, everybody understands theoretically, and that legally you're innocent until proven guilty, and you have to be proven guilty beyond a reasonable doubt, right? Everybody's heard those words 4,000 million times. But what does that actually mean? And so when I am voir direing jurors, I actually ask them, like, what do you think that means? And there's rules and limitations about what I can do, and that I cannot quantify that for a jury. I cannot quantify that for any juror. There are ways that we sort of work around that. But if a prosecutor somehow, in their argument to a closing jury, which the reason why I'm choosing this example is because this is something that Mr. Kephart did as a prosecutor, you shift the burden from the prosecutor has the burden to prove guilt to somehow, as a defendant, I have to defend myself, which is not the way that the system's supposed to work. That's called burden shifting. They have the burden. They're trying to say, no, really, I have the burden. Something like that is harmful error, because if the juror bought that interpretation of the law, which they did with Mr. Kephart, then they convict somebody on the wrong interpretation of the law. The judge's failure to correct that is not harmless. The jury heard something that is not the correct statement of the law on the most critical factor in a criminal case. They convicted somebody that shouldn't have been convicted. They got reversed. That is harmful error, reversible error. And so many of the cases that Mr. Kephart tried as a prosecutor, and this took place over decades, that those cases are all being reversed because of error that was not harmful, and error that was done by him. Yes.
Well, I want to thank you so much for coming on, and I want to let you know that there are 2 things that really make you stand apart. You're the first candidate to really, confront an opponent. In this particular case, it's an incumbent, and I think most of the messages that I get from your supporters are in awe of your courage. That's how you're being perceived by your supporters. It's that you have the guts to do something that few other judicial candidates have done. And then the second is that I didn't know your background was so diverse. I thought you were just a chief deputy public defender. Apparently you've got all the civil experience, and you even worked a little bit as a prosecutor. So there is a lot there. I hope that this video goes far and wide, and I think I just wanted to thank you again for coming on.
Absolutely. And I just wanted to thank you again for the opportunity. I really want to ask everyone that's watching the videos, I want your support. I need your support. I need your help. I'm probably not like any other judicial candidate, because I have a targeted race for a targeted reason. And I ask for voters' help because once they see what's going on, that they will believe as I do, that I've been trained, I've been raised, from my father's a veteran. I guess that made me sort of hardcore too, that you have to speak truth to power. You have to do it. If not, you deal with the results of being silent. And I think that Clark County's had enough of that from Department 19. And I think that we have work to do there. And I hope that as a public servant, as a lifelong public servant, I can be of real service to our community. So thank you again for the opportunity. I really appreciate it.
Thank you so much.